On to some specific types of alternative dispute resolution formats. First, we'll talk about is arbitration. And arbitration, a third party, and it says arbitrator, but it often would be arbitrators, maybe a panel of three is quite common. They make a final decision, a final binding decision. Mandatory versus voluntary means that it could be either. In most cases, it's voluntary. Some states have set up mandatory arbitration for almost like small claims for things under, say, $10,000 or $15,000. I just require the parties to go through that rather than clogging up the courts. Okay, the final decision, the award, is binding. Okay, it is. Why do we do arbitration? Well, it's less expensive than courts. Right, the states favor it because it eases the burden on the courts, and you get expert assistance. Oftentimes, your arbitrators they're experts in that field, in addition to the law. Okay, we hear about arbitration sometimes when we listen for like players' contracts in major sporting events like baseball and whatnot. There can be some of those can be submitted to arbitration. I don't hear it as much as I used to, but. So how do we get arbitration? Well, first, the parties agree to it, okay? And they can agree to it either before the fact or after the fact. And by that I mean before they sign a contract or at the time of signing a contract, they can agree to arbitrate disputes. That's getting to be fairly common. Or at any time during the carrying out of the contract, they can agree to arbitration. Or when a dispute arises, they can still agree to arbitration as a method of settling that. It's called a submission agreement. Okay? They can agree, to just specific matters that they might arbitrate and leave some other things out. Remember when we talk about court, we talk about judges decide questions of law, juries decide questions of fact, and arbitrators do both. Okay, there is a trend toward arbitration. We might talk about that a little bit as we go along. So, arbitrators are chosen by disputing parties, and oftentimes, if it's a bigger case, if there's three arbitrators, what happens is each side will choose an arbitrator, and those two put their heads together and choose the third person to arbitrate the dispute. Again, they have expertise. Oftentimes that expertise is beyond the common law shop, it's within that common law shop, meaning that they understand. If it's a sporting thing, they might be an expert on football. They might know, what it means to be a 1,000-yard rusher or those types of things. Probably well beyond that, actually. And so their expertise is beyond the legal. Number of arbitrators can be 1 to 3. The authority is granted by the agreement, and again, it can be limited to specific items. So the Federal Arbitration Act covers any arbitration clause that has to do with interstate commerce, and as we'll discuss, we'll find out that interstate commerce is defined very, very broadly. We'll find, I think next chapter we talk about that. I know next chapter we do. So the impact, right? The court assumes the intention, meaning they assume that there's the intention to arbitrate things when an agreement obviously has been signed, may set aside state laws under commerce and supremacy clauses. So they can agree to not allow maybe arbitration in certain cases, but it's pretty rare. The federal government and the Federal Arbitration Act are meant to say that federal law favors arbitration. So typical arbitration contracts, and the one that's not up here, that employer-employee, we're starting to see that more often. When you go to work for a place, they're going to have you sign your employment agreement, and as likely as not anymore, it may have an arbitration clause in it. It says if we have disputes, over your employment here, we agree to settle those disputes via arbitration. It's getting to be pretty popular. There's some angst about that, and the angst is this. You're just out of college. Let's say you're 24 years old. You're going to work for your first job. Your employer kind of is holding pocket aces in that case, and can kind of set the terms, right? Who's going to object to the arbitration clause? So in a sense, you're kind of giving up your litigation rights right there in a position where you're, what are you going to say? Who's going to say, I'm not going to sign the arbitration clause? Probably not, right? You don't want to get off on that foot. So at the awards, or when the arbitrator or arbitrators make an award, they disclose the findings, right, and the reasons. Okay? Those aren't necessarily needed, right, unless required by statute or by the agreement, but the parties are bound. Okay? And again, the court favors the award and the very, very broad scope of arbitration. Final unsubmitted, meaning it does get submitted, it does get filed with the court clerk, and it will be enforced by the court in that case. So, meaning that, if you get an award, it's like getting in a judgment, and so then you can use execution or garnishment maybe to go ahead and enforce that if you need to. So mandated arbitration, some states are adopting that, right? Again, usually for smaller amounts, speeds it up, lots of qualified arbitrators. There's probably a lot of landlord-tenant disputes that could be arbitrated instead of going to court. Might be a specific subject matter. Again, landlord-tenant types of things. Employee-employer, maybe. I doubt that those would be mandated arbitration too often, mainly because the amount's probably going to be higher than that in most cases. It does require recordation of the proceedings. So in mandatory arbitration, there's a claim. There is a discovery, but the scope of discovery is far more narrow than it is in trials. It doesn't take as much time, and it's a lot more narrow. The arbitrator determines similar things to what judges might, right? The admissibility of evidence. They also determine the law and the facts of the case and what objections there might be. They do have a hearing. Figure 8 months. That seems like a long time, but court cases, believe me, drag out oftentimes for years. And like I've already said, there can be a pre-dispute arbitration clause, and there can be a post-dispute arbitration clause. So the pre-dispute can come any time before, right? And usually it's at the signing of a contract. But even after contract's ongoing, you can still sign a pre-dispute arbitration clause that says, hey, if we do have a dispute, right, we'll agree to arbitrate it. And then post-dispute says that when that dispute arises, the parties still agree to be bound by arbitration. How about judicial review of arbitration? Again, the courts favor arbitration, and so arbitration is this, right? It's voluntary, it's contract-based. Award's final. Limited, meaning that the judicial review of arbitration is limited. Okay, it's got to correct these things, right? Just fraudulent, maybe arbitrary actions or actions that might be against public policy, of course, against constitutional law, those types of things. It is statutorily mandated, so there is a review, right? It's in accordance with procedural and due process law. De novo means that it's judicial review as if arbitration had not occurred, so they kind of look at it outside the lens of arbitration. It doesn't mean they retry it or anything like that, but they kind of look at it, and if it were in the court, with the same facts and those types of things lead to the same conclusion. And again, they refer often to that Federal Arbitration Act. So issues that could come up, of course, interstate commerce issues. What if it's not interstate commerce, right? Maybe then it might not or should not have been subject to arbitration. And things that we kind of mentioned already, but arbitration award may be vacated if there was actual fraud on either side or by the arbitrator. Could be any of the parties. If the arbitrators are corrupt, maybe they took a bribe or something, right? If there's misconduct or if it exceeds the powers granted to it. Okay, let's pause there and we'll come back and work on mediation and finish up the chapter.